Yes, good morning, Mr Hancock.
Good morning, my lord. My lord, my ladies, I hope that the court should have received electronically two notes. One which is by way of an aide-memoire, which I hope will enable me to be briefer in relation to the remainder of the human rights point. The other is by way of an answer to the homework that my Lord the Master of the Rolls set me in relation to the CLC.
Yeah, it's very helpful, thank you.
Can I deal firstly with the CLC point very briefly? And in relation to that, then, as the note sets out, then there are two liability regimes relevant to the Spanish proceedings. The first was the CLC compulsory insurance regime, which is known as the blue card regime, and the second is the voluntary insurance regime.
Well, I mean, it's all set out in your note, isn't
it?
And I mean, what you say is that this is not only, it's not only as set out in your note, but it's also set out in the various judgments and awards, which make it all very clear, and doesn't mean we have to reinvent the wheel.
Quite so, my lord.
So it's what it is, and we can digest it at our leisure. I don't think you need to deal with it in open court.
I'm grateful, my lord.
Thank you.
In which case, then, can I move to the second of the two?
I mean, obviously, if the states want to say it's all rubbish, then they'll tell us.
Of course.
I hope they got it more quickly than I did, because I only saw it at 10:15.
My lord, I have to say, it did not arrive at a time which has enabled either my learned junior or me to take on board what is set out in it.
Have you read it?
No.
6 pages.
6 pages or the 18 pages?
6 pages we're talking about.
No, I was in the middle of the 18 when the 6 pages
junior,
arrived.
I do think you should try and read it. It's just a question of you're telling me whether you're going to put in a long submission saying why it's all rubbish, or that you accept broadly that it's right.
My lord, I will do my best to read it in the next couple of.
I mean, the 18-page document is somewhat different. We'll hear what Mr. Hancock says about that in a minute.
But I only got the 5-page document about 10 minutes.
Yeah, well, so did I, but I managed to read it.
I'm very sorry.
Unfortunately, we have to be quick when we're dealing with these things, and I did ask Mr. Hancock to do these two things, and he's done them, and therefore we should try and realise he had to work all night overnight and his team to do this, and
my lord,
he's done it, and it's pretty helpful from what I've seen.
I will comment upon it if need be.
Yeah, I mean, you're perfectly open to say I haven't had time and I'm going to have to check it, but I'd just like a first reaction.
My lord, I will certainly do that.
Good. Yes, Mr. Hancock.
I'm grateful, my lord. And of course, Mr. Young was actually in the arbitration hearing in front of in front of Sir Peter Gross. So the references actually in Sir Peter Gross's award are references with which I'm sure he's familiar. Let me take the second note.
I mean, none of us, we don't all have complete recall of everything we've done in our entire professional careers, Mr. Hancock.
Your lordship is quite right, and I can't say that I have complete recall even of Sir Peter Gross's award.
Exactly. Keep going.
Notwithstanding having been involved in these proceedings for a long time. Going on then to the longer note. First point I should make is this note effectively is a condensation of what I was intending to say orally.
Well, it is, so far as I could see, it is what you said orally.
Indeed so.
And
in relation to the
very
first
well done, in fact.
First part of the note, the only, in a sense, further point that I do draw the court's attention to is paragraph 5.3.
Right. I only got to page 11, just so you know.
I'm grateful, my lord. My reason for drawing the court's attention to paragraph 5.3 is because there is a discussion of the Diageo case.
Yes.
And the Diageo case was a case in which there was a consideration by the Court of Recognition of error of substantive law on the part of the foreign court. So they did look at the foreign court's judgment in order to decide whether there was an error of substantive law.
I mean, I think you'd probably agree with me, wouldn't you, that it's hard cases make bad law, or it's horses for courses. I mean, the fact of the matter is courts say they're doing one thing and then do the other when they find something terrible they need to correct, and then they lay down principles which seem inviolable until they're violated. Yeah. And so it is really this kind of situation where when there is a real iniquity, the court looking at it takes the bits out of the authorities that they think gives them the way through it, and vice versa. So I think we have to make the best of that. But I take your bull point, which is that the judge took out of context the line from Moroni and did not read it against the backdrop of the other cases, and you say he should have done. And
that's right.
I understand the point.
That's right, my lord. So that's the only reason for referring the court to Diageo, and that's why that series of paragraph references in Diageo are contained in the note. The next point, my lord, my ladies, which is page 7 of the note, is as to my Lady Justice Andrew's point about whether the Supreme Court in Spain was itself considering whether the provincial court's judgment was arbitrary. And the point there, my lady, is that there were different bases for appeal.
Yes. Article
849.1 is the one with which we are concerned, which is finding new facts when you shouldn't find new facts. In relation to the arbitrariness of the lower court judgment, then that was considered in other contexts, and in particular, then it was considered in the context of the conviction of a different defendant, who was Mr. Lopez Soares, who was the Spanish gentleman who sent the vessel away from the shore, and those appeals were separate and distinct from the ones with which we are concerned within this court. And even in that context, where the court is analysing arbitrariness, it says that it cannot make new factual findings. It simply has to ask itself whether the findings of the underlying court were themselves irrational. Well, ladies, the next point is that Spain's expert accepted that there was no factual finding that any act or omission on the part of the master caused the damage. The reference to that is at the full supplemental bundles, volume 10, tab 51, at page 2818. It's transcript day 5.
Sorry, 211818.
So tab 51, page 2818.
It's set out in paragraph 13 of the note.
Indeed. So it's just really to give you the reference to the fact that that was accepted by Spain's expert.
2818 is the page, is it?
Yes. Then paragraph 16 of the note, then, and this relates to my lord, the Master of the Rolls' concern as to the nature of the requested review of judgments of a friendly foreign state, then the court has the point already that it's permissible to review errors of law within the limits identified in the cases in the European Court of Human Rights, and also within the courts of the member states who apply similar principles, as I showed your lordship and your lordships yesterday. And the second point in that is that insofar as this court does not feel able to reach a properly informed view as to whether or not there were such failings on the part of the Spanish Supreme Court, the appropriate remedy in my submission would be to remit the matter to the trial judge, on the footing effectively that the trial judge did have lots and lots of evidence in front of him, yeah, but because of his approach to the exercise, then he didn't go into those points. My lord, then going on to page 10 of the note, we get on to, in a sense, where I had paused yesterday.
Right.
And the next point is exhaustion of legal remedies. there is no express requirement that the defendant must exhaust his legal remedies in the regulation itself. The notion in this regard comes from the Advocate General's opinion in the Diageo case, and that is at the Authorities Volume C, Volume 4, page 1169, at paragraphs 63 to 67. This is all in paragraph 17 of the note. There are 5 propositions which emerge from that, set out again in writing in the note. The purpose of requiring exhaustion of remedies is to concentrate the correction of substantive errors in the court of origin. The idea is that if the court of origin, that you should give the opportunity to the court of origin to get it right, and remedy the defect. The second point is that the requirement does not apply where specific circumstances make it too difficult or impossible to make use of the legal remedies. That's paragraph 64 by the letter C. Thirdly, that is a general rule, but not an invariable one, because these circumstances have to be taken into account. Fourthly, the application of the principle is a case-by-case one according to the specific circumstances of the situation in question. Fifthly, this is paragraph 66, then there is a reference to the Hess, Pfeiffer and Schlosser report. The control of the foreign court should at least be retained when the member state of origin does not provide for an efficient remedy, with the emphasis on the word efficient in those circumstances, in that quotation. The Court of Justice at paragraphs 62 to 63 adopts the Advocate General's approach, adds a reference to the matter being based upon mutual trust and the working assumption that the Court of Origin plus the preliminary reference procedure will give sufficient guarantees to individuals. That coincides with the approach taken to the exhaustion of domestic remedies in the European Court of Human Rights. The underlying principles are the same, and in Moroni, that is reflected in paragraph 49, where the Advocate General observes the consistency between the Diageo approach and the Strasbourg case law. The European Court of Human Rights approach is summarised in the DH case, and that is, this is in the note 2, Authorities Volume C, tab 45, page 1532, at paragraphs 115 to 116, showing the similarities with Diageo. The rule is based on the assumption that the domestic system does provide an effective remedy. There have to be effective remedies which are available in theory and practice at the relevant time, which means, it is said, that the remedy must be accessible, capable of providing redress in respect of the complaint, and offering a reasonable prospect of success. Then paragraph 116, 4 lines down, the rule should be applied with flexibility and without excessive formalism. It is neither absolute nor capable of being applied automatically, and it is essential to have regard to the circumstances of the individual case. That all reflects the reasoning in Diageo. That means taking realistic account not only of the formal remedies, but the general context in which they operate, as well as the personal circumstances of the applicant, examining whether in all of the circumstances of the case, the applicant did everything that could reasonably be expected of him. And then at 119 to 122, there was the application of the law to the facts of that case, and those facts involved the fact that a number of parties had actually made an application to the Constitutional Court, which had been rejected, and the court held, well, there was no reason to suppose that the application made by other complainants would have been accepted by the Constitutional Court. In this case, then we would submit that the club cannot be expected to have done anything more about the arbitrariness of the judgment. Firstly, it was suggested that they should have participated in the liability stage, but of course that would have involved the risk of submitting to the jurisdiction. By the time of the provincial court decision, the club had already established its right to have the dispute resolved in London arbitration. Sir Peter Gross held that the club had acted entirely reasonably in not appearing in Spain in those circumstances because of the risk of submission. Even on the terms of Diageo, therefore, there was no relevant failure to use remedies at that stage. In fact, in any event, there was no remedy needed prior to the decision in the Supreme Court. The problem only arose from the decision of the Supreme Court. Before that, there was nothing to remedy. If one then asks, well, what steps could have been taken to remedy that problem, the answer is, firstly, that a nullity application had no prospect of success, or no reasonable prospect of success. It would not therefore have been an efficient remedy. The fact of the matter would be that the very same tribunal would have been considering that nullity application. It's scarcely to be concluded that that same tribunal would have reversed itself. The second is the Amparo appeal, and that's the appeal to the Constitutional Court. The judge didn't think that this was a remedy which should have been used. Mr. Urenia's evidence was that it probably wouldn't have been admissible because the matter would not have involved a constitutional question. So no efficient remedy there. Then at the quantum stage, there was no efficient remedy because the defects arose out of the liability judgment. And at the quantum stage, nothing further could be done because at the quantum stage, the liability judgment could not be questioned. My lord, my ladies, you will see that in the award of Dame Elizabeth Gloucester, where this point was raised, and she rejected that. That is in Core Volume 4, Tab 38, page 854, in paragraph 76, subparagraph 6 of the award. Spain suggests also that the club could have made a European Court of Human Rights application, but Diageo itself does not refer to the need to use international remedies, so the point goes nowhere. So finally, even if the court were minded to consider that the club could have done more to raise the arbitrariness complaints in Spain, that is, in the final analysis, a matter to be taken into account. It's not a complete bar. And in all of the circumstances of our case, including the unlikely outcome that attempting to utilise further remedies would have achieved anything, then we would submit that the serious arbitrariness in this case would not have been remedied. There was no, and that therefore this should not preclude the club, the court, from refusing recognition. It's one matter to be taken into account, but when the court does take it into account, the conclusion should be it wouldn't in fact have there wouldn't in fact have been a remedy. Hello, that's everything, my ladies, that's everything I was proposing to say in relation to the CLC ground. As I've said, I wasn't proposing to say anything at all in relation to the 45-1 ground that Professor Webb addressed the court on yesterday. That just leaves the new facts ground. The nature of the fundamental right is explained at paragraph 18 of the club's skeleton. The first question, as also in the club's skeleton, is the meaning of manifestly. The judge, rather than accepting the submission that a manifest breach is a breach which is a particularly important or grave or serious violation, he instead approached essentially the matter on the basis of a heightened standard of proof. He said that it had to be obvious that there was a breach of human rights, and if it was even arguable that there wasn't a breach of human rights, that would be sufficient. That, with great respect, is erroneous. The suggestion that it is only possible to rely upon the public policy ground where the allegation of a violation is unanswerable is putting the matter far too high. The example we give is that there may well be cases where there is room for serious argument as to whether there has been a violation. For example, whether a judgment has been procured by bribery or corruption. If, after a careful scrutiny, the court finds that the judgment was procured by bribery, it can't possibly be right that just because it has taken some time to analyse the evidence and situation to reach that finding, that actually means that the relevant judgment was not manifestly in breach. The court in those circumstances should refuse to recognise and enforce the tainted judgment. So in principle, the judge's approach was wrong. And the judge's approach does not have any authority in its favour. He quoted two cases. The first was the case of Laser Point, which is Authorities Bundle, Volume C, tab 24, page 678. Paragraph 60 says that the recognition must be plainly or obviously contrary to public policy, but it doesn't say that there must be no room for serious argument as to whether there is such a violation. On the contrary, then looking at the judgment itself, and I'm not proposing to take the court to it, if you look at paragraphs 4 to 31, there is a lengthy recitation of the facts, and at paragraphs 32 to 59, there are detailed arguments as to why there was not in fact such a violation. The judge didn't therefore say, there is a different standard of review that applies in relation to this allegation, and therefore I don't need to go into the exercise of examining the matter in detail. The judge did examine the matter in detail, and that is entirely inconsistent with Mr Justice Butcher's approach, with great respect to him. The second question, the second authority is Smith against Huertas. Mr Justice Butcher relied upon paragraph 16 of that judgment, where Mr Justice Cook held that manifestly meant that it must be obvious that public policy dictates refusal, but again, there's nothing in Smith and Huertas indicating that there was a modified standard of proof in this regard. Once again, the way in which the case was in fact decided runs contrary to Mr Justice Butcher's approach. If one then looks at the judgment itself, then the facts of the judgment were as follows. Dr. Smith sought a declaration that Mr Huertas was not entitled to have the French judgment recognised or enforced because it would be contrary to public policy. Mr Huertas applied for summary judgment dismissing the claim. If Mr Justice Butcher was correct, then Mr Huertas would have had an easy task. He would merely have been able to required to show that there was room for serious debate as to whether there were such violations. But instead, he considered whether Mr Huertas could show that there was no real prospect of there being such a violation. And so once again, that case is inconsistent with the judge's approach. It doesn't support the judge's approach. Because of that error of approach, the judge again did not deal with the factual allegations on their merits. there are a large number of areas in which that was the case. Those are set out in the club's closing submissions in front of Mr Justice Butcher. But what he there did was he said in relation to those allegations, I'm not going to decide who's right and who's wrong as between the two experts. I'm simply going to ask myself whether Spain's expert has put forward a case which is cogent. In my respectful submission, that's simply not the appropriate approach. Where there was a dispute between the two experts, he had to decide that dispute. He had to decide who was right and who was wrong. And he just didn't do so. As to the appropriate remedy in relation to this breach, we would accept that this court can't deal with this breach. It would have to be dealt with by way of a remission to the learned judge if we ever get this far. Then the next point that is taken is that the violation of rights is the rights of the master and not the club. The short answer to this point is that the breach of the master's Article 6 right resulted in a judgment which was a civil judgment which was not subject to the conditions provided for by law, and as a result of that breach of the master's Article 6 rights, there was a violation of the club's rights under Article 1, Protocol 1, because the club was thereby deprived of its property. An example of that is in the case of Pogasian, paragraphs 44 to 52, and this is paragraph 32 of the note. The judge failed, in a sense, to reflect in his reasoning the way in which the liability of the club came about. This is something I referred to, I think, on probably the second day of this appeal. There were a series of building blocks in relation to the liability of the club. The first was there was criminal liability on the part of the master. The second was that criminal liability entailed a civil liability, which would be the case if the criminal act had caused the relevant loss. The third was that the owners were therefore vicariously liable for the liability, the civil liability of the master. And the fourth was, well, the fourth in a sense was then the CLC question, that liability was for the amounts in excess of the CLC limit. And then the fifth step in relation to the club is that because of the civil liability of the owners, the vicarious civil liability of the owners who were the assured of the club, therefore the club actually was liable under its insurance agreement. So all of those building blocks put together, the first step in that regard, the first building block was the finding that the master was guilty. And that appears from the terms of Article 109.116 and the Supreme Court judgment itself at page 129 internally. The civil liability results from a crime and the civil law redress for the criminal law, the criminal act committed. So, putting it in short, then the unfairness, which in turn led to the conviction of the master, which in turn was a necessary constituent in the civil liability of the master, owners and club, was the whole basis of that exercise was unfair, as a result of which recognition of this judgment, which only flowed from an unfair procedure, would amount to countenancing and propounding that unfairness within the English legal order, which in turn would mean that there was a breach of Article 34, subparagraph 1. The fourth point that is then taken, I'll take this as briefly as I can, is the relevance of the rejection of the master's arguments in Spain and Strasbourg. The judge took the view that the rejection of the master's complaints in Spain and Strasbourg precluded the club from running the points now. This is paragraphs 76 to 83 of his judgment, and he relied upon the decision in Smith and Huertas. But those cases do not apply to the present case. Smith and Huertas, one case, the second case was Interdesco. If those cases are correctly analysed, they do not apply to the current case and should not be determinative. If we start with Interdesco, then the analysis in that case was about whether the usual principles of estoppel should apply to a convention judgment to prevent reopening that judgment on the basis of fraud at the enforcement stage, or whether they should be subject to the different approach which the common law took to fraud in relation to foreign judgments. Justice Phillips said that in relation to, as he then was, in relation to convention judgments, the English court should normally leave the defendant to pursue his remedy in the foreign court, and it should normally not entertain a challenge where it wouldn't have allowed a challenge to an English judgment. In both of those instances, normally is the word utilised, not always. In Smith and Huertas, then the enforcement proceedings involved the same parties as the French proceedings. There was room, again, therefore, for principles of estoppel to apply. Mr. Justice Cook, however, in our respectful submission, misapplied Interdesco. He cited Interdesco at paragraph 19, including its references to, quote, normally, unquote, but then at 21, he moved from that statement, saying that you should normally leave the defendant to the foreign court's remedies, to effectively finding that you have to leave the defendant's fate to be determined by the foreign court. In our submission, then, the approach of Mr. Justice Phillips is to be preferred to the approach of Mr. Justice Cook, because it is a more nuanced approach and because it therefore enables the court to respond to the circumstances of the particular case. Otherwise, if the court simply applies the approach of Mr. Justice Cook, then it is a potential recipe for injustice, because it would mean that however unfair the proceedings in the foreign court, the Court of Recognition has no choice but to recognise that judgment. Whereas the nuanced approach that was preferred by Mr. Justice Phillips leaves room for flexibility and avoids what we would submit is a wrong conclusion. So, in sum, in relation to these two authorities, Interdesco and Huertas are based on estoppel principles, which do not apply in our case because the parties are not the same in our case. The judge elided the position of the master and the position of the club. That elision was erroneous. Secondly, then, in relation to the master's nullity petition and the Constitutional Court judgment, the normal position of leaving a defendant to his foreign court remedies should not apply. Neither of those routes offered a real or efficient route to the giving of a remedy. Thirdly, in relation to the European Court admissibility decision, at the very most, this is something that the English court should take into account, but in this case, as this court knows, then this was a decision of a single Andorran judge, which was effectively unreasoned. And in those circumstances, then, we would submit that that decision can be given little, if any, weight. the material part of the decision contains just 2 sentences saying that complaints do not disclose any appearance of a violation and are therefore manifestly ill-founded. As I've said, unreasoned. We don't know what the quality of the review was or the quality of the reasoning behind it was. There are institutional reasons to doubt the quality of the review. That decision was made under the Protocol 14 procedure. That was a procedure which was brought in specifically to reduce a massive backlog of cases pending in Strasbourg. And we've given some references in the note to some articles as to the nature of those applications and the fact that they are or may be dealt with cursorily. And then finally, then that decision was examined on the papers alone in circumstances where there was a maximum 20-page limit on submissions, but without the benefit of the detailed factual and expert evidence or written oral argument that there has been before the English courts. That would be a good reason in and of itself for the court to take its own view as to whether violations had occurred. And lastly, the UNHRC decision is really irrelevant because that was a procedural decision on the basis that since another body, in that case Strasbourg, had considered the merits, however limited that consideration was, then it could not consider those matters further. And finally, failure to exhaust remedies in this context, then I really just reiterate what I've said already in the context of the previous ground, that there were no efficient methods of challenging the decision, and in those circumstances then pursuant to cases like the DH against Czech Republic case, then the club was not required to take steps which had no prospect of success. My lord, my ladies, unless I can give any further assistance to the court in relation to this ground, those are all my submissions.
Thank you. Thank you. Good. Who is speaking on behalf of the estates this morning? Ah, Ms. Patel, good morning.
My lord, my ladies. Can I prefix my remarks by saying that I only received the note of 18 pages at 9:15 this morning.
That was an hour before me.
Well, I'm probably, as like Mr. Young, a much slower reader than my lord, so apologies for that. And I was partway reading it when I received the CLC note, so I have not completed my review of the 18-page note, and I will embark upon my submissions.
I don't think it says anything very new, actually.
You may well be right, my lord.
It's quite nicely encapsulated, but I mean, it certainly helped me anyway. It reminded me of what the arguments were. Anyway,
I'm very glad to hear
you must do your best.
I will do my best, and I will finish reading it over the lunchtime adjournment.
Well, we may not get to the lunchtime adjournment. We're hoping that 6.5 days are going to be sufficient for this appeal. But anyway, let's keep going.
I had, subject to the court's views, 7 sections to my submissions.
Right.
I wanted to make some introductory remarks about how the appeal is framed, firstly. Secondly, I wanted to deal with the legal framework, and in particular 4 topics which address the prism through which the Article 34(1) questions are to be approached. And those are the topics of...
Well, you do say the judge was right, do you?
We do say the judge was right.
Yes.
We have a respondent's notice with some additional reasons which the judge could have relied on. We do say the judge was right. Thirdly, I wanted to deal very briefly with some points in relation to the factual background and the chronology of the proceedings leading up to the latest UN Human Rights Committee decision that you heard you were addressed on yesterday. Fourthly, the new findings of fact. I wanted to deal with that first because it seemed to me it's important to go to that and the Strasbourg decision first, because we say that is actually very much the foundation of much of the irrationality complaint that's made. And so how that was treated is relevant to the irrationality complaint. Fifthly, I wanted to deal with the alleged no higher review under Article 14.5 of the ICCPR, and I will sweep up points in response to the note that was handed up yesterday when I do that. Sixthly, I wanted to deal with the alleged arbitrariness and irrationality last, because that is where I think it's properly placed. And then finally, some short concluding remarks. May I say that to the extent that the court may be assisted on detailed factual matters and the detail of the exercise conducted by the Spanish court, Mr Young would be delighted to assist, given his involvement in the debates on this very topic over the 7 days before Mr Justice.
And how long do you estimate your submissions to be likely to take?
Well, my lord, I had been working to the timetable. I believe we are still on the timetable. Mr Hancock was due to sit down at 11:15.
Right. So what is the answer to my question?
The answer is 3:30, I believe, for me, with half an hour reply for...
All right. Well, we're just going to rise for 5 minutes.
Rise the table.
Yeah, I said it, yeah. Sorry, yes, yes. No, yes.
No, no. How are you doing? I leave in August now. What, on Friday? So what are you doing? You look like you've been quite well as well. The whole hearing. I didn't know. Just a book. Oh, right. No, I just thought yesterday they There were levels of, yeah, exactly. There were levels of unwell. Probably. I'm sorry about that. You're all right to be here? Yes. At some point. No, no, I seriously need to. No, that's right. It's all happening. I'm just reading manically. I've got to go to 9 a.m. on Monday. Yes, that's happening.
Many coastals.
Yes, that's very good. Sounds about right. Yes. Yes. It'll be
although now I've got basically told, you know, there's that chapter in once it starts, and the process, the actual process, because I really, there's none of the case, the process is great. Literally on stars, and it worked out really nice because he wanted to know all the things I had. He did like
Court rise at table.
Yes, thank you, Mr. Chairman. On you.
This appeal concerns 3 complaints made by the club that variously relate to rights that are not its rights, involve this court, asking this court to review complex findings of fact and Spanish law on the basis of translations and in the absence of the relevant evidence. The complaints are made notwithstanding that Spain did not participate in the underlying Spanish liability proceedings. Where complaints were raised to Strasbourg, they were dismissed. Where complaints were raised to the non-judicial body, the UN Human Rights Committee, whose views are not binding, they were either dismissed, or where they were upheld, it was in respect of a right not recognised by the European Convention on Human Rights within the European space, and with a paucity of reasoning in relation to why the Spanish appeals that were available to this club were not adequate based on the nature of the complaints that were made here. The standing back, the effect of the club's position is that any party that does not submit to the jurisdiction in foreign proceedings because they wish to deal with matters elsewhere is entitled to come to the foreign court and ask the foreign court to conduct essentially a trial in relation to Spanish law and Spanish evidence to vindicate its human rights. And that is a very extreme position and not one which we say is contemplated by the Brussels regulation. In relation to the complaints in the High Court were split into 4. The High Court grounds of appeal, I don't ask you to turn them up, but they're in Core Bundle 2, Tab 12, 3.18, 318.2. The first was the new factual findings complaint. The second was the UN complaint, I'll call it that. And importantly, in relation to that complaint, it was not argued in the High Court that it would be contrary to customary international law for this court to recognise the Spanish judgment. In fact, the opposite position was taken by the club before Mr Justice Butcher. And you have those references. If I just give you the references, the club's opening submissions are at paragraph 107.
So just say again what this submission is.
The submission is that the submission which is now advanced by the club before this court.
Which
it would
position?
Be contrary.
Which one?
It's the UN complaint that it would be contrary to Article 14.5.
Oh, that one.
Customary law.
To recognise the judgment because Article 14.5.
Sorry, I'd forgotten it was 14.5.
Yes.
Customary international.
The argument now put is that the reason that is a good point, notwithstanding that the the ICCPR has not been incorporated into English law, is because in fact Article 14.5 reflects customary international law. Now
that's a big statement.
It's a big statement, and it's surprising that it's advanced now. And
that's you say directly contrary to what they said.
It's directly contrary, which is perhaps less surprising because, as my lord says, it is a big statement. It's therefore not a statement that was made before Mr Justice Butcher.
I mean, we got that in about 5 minutes, didn't we?
You got that in about 5 minutes.
We didn't look at Ben Caboose. We didn't look at various judgments of Lord Sumption that have
my lord, yes.
Explained all this.
And my lord will be aware from the resolute in other cases that the question of whether a rule of customary international law exists is quintessentially a rule of evidence.
Yes.
And therefore, my lord will be alive to the problems of not advancing that argument below.
Mm.
Yes.
And the problems of, if I say, essentially giving some evidence to the court yesterday, but not in the quantities that one sees in cases like the Freedom and Justice Party, where these matters are properly before the court.
Well, when it's actually what the case is about.
Yes. But if I can just give my lord the references to where the contrary position is taken by the club below. It's paragraph 107.4 of the opening submissions, which is in supplementary volume 3, tab 14, and the page on the paper page is 627.3. And then closing submissions, paragraph 147.1 and 147.9, supplementary, volume 3 again, tab, that doesn't appear to be right, can I just check that?
Forgive me.
So that is supplementary, volume 3, tab 16, pages 808 and 810. And I will deal with why it's a bad point when I come to that head. But when my lord, my ladies look at those closing submissions, can I just ask you to note the length of them? They run to hundreds of pages, the submissions that were made before Mr Justice Butcher, and I understand yesterday there was some suggestion that the quality or detail of the argument.
So you said there were 3 complaints.
Yes.
New factual findings, 14.5.
Yes.
What's the third one?
The third one was separated below, and it's now brought together, and you can see that if you compare the High Court grounds with this Court's grounds of appeal. But it's essentially that it was contrary to Article 6 and Article A1, P1 of the European Convention on Human Rights, because the Spanish Supreme Court judgment was arbitrary and manifestly unreasonable in respect of its findings on civil liability. And therefore the judgment interfered with the club's right to peaceful enjoyment of property.
I mean, I don't know why, but I sort of understood that was the nub of the whole thing.
No, they are 3 distinct complaints, my lord, and it's very important to keep them separate because they relate to different human rights obligations which are said to arise. They relate to the first 2. Perhaps we can just turn up a grounds of appeal to this court to make the point good, but there are 3 important differences. That's Core Bundle 2. Tab 16. page 344.
417 for us.
What was that, my lord?
417.
417. Gosh, that's quite a big...
Oh, it's completely, these bundles are totally disastrous. I mean, seriously.
Well, I add my apology to all those that have gone before, my lord. So, if we start with 1, 2 over the page, that is new factual findings. The judge erred in rejecting the contention that recognition would be contrary to public policy. Yeah. There's ICCPR rights which are now not relied on in relation to that heading. It's Article 6, 47 of the Charter. Master was convicted by the Supreme Court on appeal against acquittal on the basis of new factual findings. So that is about the Master's conviction. The second one in the order that I took them is on the previous page, 1.1. That's the UN ground. Recognition would be contrary to public policy, including by reason of the right guaranteed by Article 14.5. On the basis the Master was convicted by the Spanish Supreme Court on appeal, from which the Master had no right to have his conviction and sentence reviewed by a higher tribunal. Again, that is the Master's conviction. And then the last one, which Mr Hancock took first, is 3 in brackets on 345. 418. The judge erred in rejecting the contention that recognition would be contrary to English public policy, including by reason of A1, P1 and or Article 6, and then the Charter provisions on the basis the Spanish courts interfered with the defendant's right to peaceful enjoyment of property, reached a decision which was arbitrary and manifestly unreasonable. So that one, which combines 2 of the grounds that were below, is the only one that directly confronts the civil liability of the club. And these distinctions are important when we come to look at whose rights can you rely on because of the nature of the obligation involved, and who should have exhausted domestic remedies and what did they do and what happened.
Does this apply to France as well?
Forgive me. It does because they're relying on the Spanish judgment. Sorry, what was said?
My lord,
My lord.
if I can help, I think the answer to your lordship's question is no, because France has not actually had its judgment recognised.
Right, of course.
So,
of course.
It's...
but it does not rely on the Spanish judgment.
It may do. It's entered a, if you like, a precursor to an application to enforce or recognise in this country.
Right.
That precursor being a step it's taken in Spain, but it hasn't actually made an application of the sort that Spain did, leading to Master Cook's decision.
My lord, France has not applied for recognition or enforcement under the regulation. There was a preliminary step taken in Spain to get a certificate so that one can then start that process over here. But that was 5 years ago, and nothing has happened since. So nothing is happening. And this isn't our appeal, so I'm just on a watching brief, so forgive me.
But you weren't here yesterday?
My lord, no, because France weren't party to this appeal, and we didn't think that human rights would have anything whatsoever to do with the preceding part of the appeal, the equitable compensation, the injunctions against the state. That's why I was, if you like, stood down. Equitable compensation then came up yesterday afternoon, which we weren't expecting. We saw it on the transcript. And the CLC, and so I've been sent back.
You come back just in case.
Just in case. That's the only reason I'm here, but we are not otherwise parties to the appeal.
So that's why the mention of France surprised you and caused consternation in the court.
Oh, yes, and me, and for France. So I'll
Sorry,
sit down
Mr.
again now.
Tell. I was looking at the respondent's notice before I set that hair running. Is that at paper page 375, electric page 448?
Yes. I mean, that relates to the arbitrary, unreasonable ground.
And it's all about the European Court of Human Rights. Is it all about that?
Yeah, it's not all about that, but so the first point is that when you look at the
page 375 on the screen.
No, I'm somewhere else. I'm looking at 448, which is Miss Patel's respondent's notice.
Yes, it's just that on my screen, my lord, and we still had the grounds of appeal.
Yes, we do. Now we've
actually
got it.
Changed to the respondent's notice.
We've got it now.
So the first point is that if you look at what was raised by the master before Strasbourg, there is a complaint about A1P1 in relation to the civil liability on the basis that it is derivative from the criminal liability, and there is a complaint. It's not advanced in the detail that it's advanced now by the club, but there is a complaint about the irrationality of reasoning. So we say that there is an argument available to Spain, which is that if it's right that the new factual findings ground is unmeritorious because Strasbourg has dealt with and dismissed it, then the same could be said of this ground. The second point is about
the rights of the master and the owners.
yes, and again relying that in essence it is a complaint about if it is a complaint about the if it is in fact a complaint about the factual finding process and inconsistent findings, then by analogy with the new factual findings argument, the rights of a third party can't be relied on. And the last point is in relation to the owners, and it's simply that the club's argument relies in part on an infringement of the owner's rights in its argument about irrationality, and that the owners also failed to take any steps or exhaust any domestic remedies, and therefore by parity of reasoning, that's a further reason why that ground in relation to arbitrariness shouldn't be available to the club.
Yeah.
So, returning to Mr Justice Butcher's judgment, I'll go to it in detail in relation to each of the complaints, but the headline, the framework is that Mr Justice Butcher considered each of three limbs of argument, and he had three reasons for each of them for not accepting the club's submissions. So in relation to the new factual findings argument, he said firstly the club's complaint is about breaches of the master's right. That's judgment 75.
75.
Paragraph 75. Secondly, and that was because the rule about new factual findings is a rule in relation to criminal cases. It's not a rule in relation to civil cases. And the complaints here are really about new factual findings in relation to the civil liability aspect of the judgment. Secondly, the complaints had already been considered and rejected, including by Strasbourg. That's judgment 76. And thirdly, it was not plain and obvious that new material factual findings were in fact made by the Spanish Supreme Court. That's judgment 84.
But he says plain and obvious wrong test.
Mr Hancock says that that was the wrong test, yes. But that is one of three reasons. So, for example, my lord, if the court accepted that Strasbourg's dismissal of this complaint was sufficient reason for why there could not be a breach of English public policy in relation to it, then in my submission, even if there were any error in relation to that test, it wouldn't be material. It would still be, if that is a sufficient reason that Strasbourg has dealt with and considered the complaints, and this court doesn't need to do more, then that would be sufficient.
I mean, why? I don't completely understand the rationale. I mean, Strasbourg is a different jurisdiction. It's dealing with the master's rights. It's a single judge. It's a fairly exiguous treatment. why, as a matter of juridical analysis, does that prevent the argument being raised before us?
The argument, well, when I come onto the legal framework, you'll see that.
Well, what did the judge say? Why did he say it mattered?
Well, the judge.
Is this paper 84? Is it?
Yes. The judge says, in the same way as in Smith and Huertas, I consider the complaints have been raised, decided adversely. The club is now seeking to challenge the substance of the decisions to reject those complaints. While it's the case that the challenges in Spain and the European Court of Human Rights were made in the name of the master, it seems quite clear that the club was involved in those challenges and probably funded them. In any event, the club's present complaint is that the master's rights are violated. If it can effectively rely on those rights at all, which in my judgment it cannot, as set out in my first reason under this heading, it cannot avoid the consequences of the fact that these precise complaints have been raised and rejected by the courts, which must be treated as the best place for them to have been raised and determined. Now, these are complaints about Article 6 of the European Convention on Human Rights and violations in relation to the master's rights not to have new factual findings. I will show the court that precisely those complaints were raised both before the Spanish Supreme Court in the nullity petition and the Spanish Constitutional Court in the Amparo appeal. They were then taken to Strasbourg, and the Strasbourg court dismissed the application as inadmissible. That inadmissibility decision was upheld by the UN, was recognised by the UN Human Rights Committee as a reason why that part of the complaint was not admissible before it. And in doing so, it looked at and was satisfied that the reasoning given by the Strasbourg court was sufficient. And the Strasbourg court must be taken to be the arbiter, the best arbiter of, it is the highest court which adjudicates on Article 6 complaints and whether or not there has been a violation. The prison under Brussels is whether there has been a manifest breach of a rule regarded as essential, and I'll deal with that under the legal framework if I may. The Strasbourg decision is a decision which this court has to take into account under Section 2 of the Human Rights Act. In my submission, it would be very surprising if this court were to take into account a decision of Strasbourg that has been recognised as sufficient by the UN Human Rights Committee, as notwithstanding Strasbourg's treatment of it, a judgment which revealed a manifest breach of a rule that's essential to English public policy viewed within the EU limits. It would be very surprising, and it would have the effect of asking this court to do, it would have the effect of going behind the Strasbourg decision on essentially the same.
I mean, there's nothing in the point that it's only a two-line rejection of the application.
There isn't, my lord. There was detailed correspondence after that judgment in which the club raised its complaint that it wasn't reasoned, etc. The registry wrote back to explain the use of this procedure, the fact that it's common, the fact that it doesn't mean that there's been no examination of the merits, but that it is that sort of, if you like, short decisions are sent out to explain what has been done for reasons of efficiency in terms of reporting back to parties, because the procedure is intended to provide procedural economy to deal with a large number of cases before the court, but that it doesn't mean there has not been an examination on the merits. And in my submission, if this court were to take the view that those decisions are not adequate in some way, the effect would be very serious inroads into our acceptance of Strasbourg as the ultimate arbiter of complaints of this kind. So,
well, I mean, you say complaints of this kind, but we're dealing with new factual finding.
yes, but the same, my lord, the same logic would apply to any complaint. We're looking at new factual findings here, but the same complaint would arise in relation to any decision of the Strasbourg court, in relation to any article under the convention, which was prayed in aid, where any decision of a single judge decided that that decision was inadmissible.
Because the new factual findings point is an Article 6 point.
It's an Article 6 point. It's a different facet of Article 6, if you like, than arbitrariness and irrationality. But the logic of going behind the decision of a single judge is not restricted to Article 6 cases or new factual findings.
So there has to, so I mean that could be the end of the matter.
Yes. Well, what I'll seek to show the court is that in relation to each of these three complaints, there are three different limbs on which the learned judge decided the matter. And therefore, this court...
The ECHR one is conclusive, if you
well,
like.
It's conclusive on new factual findings.
And A1P1.
And potentially A1 and A1P1. But
did A1P1, was it, did they raise A1P1 if it was then in the master?
The club hasn't raised anything ever because...
no, it was A1P1 raised with the European Court of Human Rights?
By the master.
It was. Right. So it's conclusive on that, but not Article 14.5.
Yes. So in relation to Article 14.5, the second limb, the judge rejected the complaint about recognition on this head for three reasons again. The first is that Article 14.5 was not part of relevant English public policy, and that's got two heads to it. So it's paragraphs 55 and 62 of the judgment.
So how did they get permission to raise Article 14.5 in front of us?
I'll take you to
something else.
I'll take you to the permission decision, my lord. So it's at tab 22 of the core bundle.
Permission decision.
Permission decision, ruling on permission to appeal.
Core bundle 22.
Core bundle. My bundle is 456.
Yeah, it's 529.
And paragraph 2, the learned judge says, in relation to permission to appeal, I formed a clear view as to what is the correct resolution of the human rights issues. So the learned judge is talking about all of them. But it's a low bar, essentially, for permission to appeal, so I grant it. There is no reasoning as to any particular points of merit in the club's arguments. On the contrary, the judge forms the clear view that he's got it right.
Yeah, but he can only be giving permission to appeal on grounds that have been put before him, presumably in relation to arguments that were had before him. What I'm struggling with is how you can do a complete 360-degree turn and say, we're arguing X in front of the judge and he got that wrong, so we want to appeal against that finding because he got it wrong on the basis of those arguments. But now we want to raise completely different, the opposite argument. How does the leave to appeal even relate to that?
Well, it does. We would say, my lady, it doesn't.
You'd say it wouldn't, yes.
We would say it doesn't.
So do you say they didn't get permission to appeal on 14.5?
No, I think my lady, Justice Andrews is making the point about customary international law. They did get the right to appeal on Article 14.5, but you can't recognise the judgment because it's a breach of public policy because there was a violation of the master's rights under Article 14.5. The club will no doubt say that's broad enough to encompass the argument that that's because Article 14.5 represents customary international law. We would say that's a different argument.
And it was the CIL argument that they rejected below.
They didn't advance.
Didn't advance.
I mean, is it helpful to go to that now, where they say they didn't advance it? I can send it.
But I mean, hang on a second. They didn't advance. I see. They didn't advance it below, but they now want to advance it in support of the ground they got permission for.
Yes.
And you say what? They can't.
Yes. Well, it's actually it was almost a concession below.
Point of law.
It is not a rule of customary international. Even though it's not a rule of customary international law, they said it's still something the court can take into account. Perhaps we should just go to it.
Yeah. This would be in the supplementary bundle.
Yes, it's supplementary bundle 3.
These are the closing submissions.
These are the closing submissions. And it was 808
808 is the page.
It's paragraph number 1471,
Sorry, tab.
tab 16.
Thank you.
So 14.1, even though there's no equivalent of the Human Rights Act in relation to
Even if it is not customary
Yes.
international law.
Indeed, a lady. And then over the page, over 2 pages,
Sorry, I'm still catching up. What page are you on?
sorry, it's 808, a lady.
820 in your bundle.
Thank you. And it's 147 subpara 1.
I mean, the problem with raising the customary international law point now is that it depends on evidence, as you say. I mean, as we know, it's rather a complicated question as to whether something becomes customary international law, but it's not a question that we can determine on the hoof. And there's no decision below because they didn't ask for one.
There's no decision and there's no evidence.
And then in subpara 9 on page 810, it says that Spain has submitted it's not a rule of customary international law or a peremptory norm, but this is beside the point,
Yes.
says the club. The question is not what the public policy of the world is. The question is what English public policy
Yes.
is.
So we do say it was advanced on a directly contrary basis below, and the complaints yesterday about the paragraphs of the learned judge's judgment where he talks about the non-justiciability of treaty obligations are misplaced, because the reason the judge approached it that way is because that is how it was put below.
So if we were with you on that doesn't bounce out the 14.5 point completely.
No, because there's still the judge's reasoning on the part that was advanced before him,
Yes.
on which you haven't heard oral submissions. Because I think I'm right in saying that Professor Webb yesterday really limited herself to the customary international law argument. I did have some points in response to that, because I say even the analogies that she sought to draw on the evidence given yesterday with Freedom and Justice Party, for example, are bad ones.
Yes. But you have a more fundamental point, which is you just can't say.
Yes.
Not at this level.
Yes.
Yeah. Okay. So the shape of this really is that I mean, I know I'm trying to cut through it, but the shape of it is there are 3 points against you.
Yes.
New factual findings, which is an Article 6 point, the A1, P1 and arbitrariness, which is another Article 6 point, and the 14.5 point. The first two are bounced out by the fact that they tried the European Court of Human Rights, which is under Section 2 of the Human Rights Act we have to take account of and is the final arbiter. And they lost. And the third one is they can't now raise private international law. They're obviously only trying to raise it because otherwise it's irrelevant to our decisions because it's not binding on ours.
Yes. Customary international law.
So
Yes.
Article 14.5 is all very interesting.
Yes. Yes. I mean, if the attack on the judge's reasoning in relation to 14.5 is maintained, despite the fact that Professor Webb didn't rely on it, then you have the judge's reasoning. He says 14.5 is not part of English public policy.
Yes.
That's judgment 55. He
Yes.
said even if it were, it's not part of relevant public policy, bearing in mind the EU limits to that concept, because you have a directly contrary provision in the European Treaty in the form of Article 2 of Protocol 7 to the European Convention on Human Rights, which specifically creates an exception in relation to higher review for convictions on appeal following acquittals. And so even if it were part of English policy, because we've got these EU limits, it's the obligation is directly contrary when you look at those EU limits. Those are the two heads to his first point. His second point is, again, it's a complaint about breaches of the master's rights. That's judgment 63. And then thirdly, he says the club is advancing this point, and the club didn't avail itself of legal remedies in Spain to contest its civil liability. Thirdly, so those are the three headings. And then in relation to arbitrariness and irrationality, there are also three bases on which the learned judge dealt with the complaint that was made. He said, firstly, the club's complaints are an attempt to invite the court to review the substance. That's the argument about what is the test and how did the judge apply it. That's 122, judgment 122 and 123. Secondly, he made a point that my learned friend has not addressed you on, and I will need to take you to the authority on it, which is that the club has not overcome the strong presumption that the courts of the originating member state will have provided a procedure which is compliant with Article 6. Yes. That's the Maronia case.
Which one?
Maronia.
Maronia, yes.
And it's an important case because I think it explains some of the debate that happened yesterday afternoon about how you square the task of this court with the prohibition on not reviewing the substance, as I'll explain. And then the third point, the limb, there, is that the club did not avail itself, again, of legal remedies available in Spain to contest its civil liability, because this, again, is about the club's civil liability, and that's judgment 126. So, in order to succeed on the appeal overall, the club has to establish that Butcher was wrong in at least one of those three separate limbs, where in each respect he based his conclusion on three independent, we say, bases.
You say even if they were right on one point, for example, just at random, that he was wrong to say you can't review the substance because you've got to be able to review the substance in order to determine whether a decision is irrational. It doesn't matter, because you then get to his next objection, which is that you can't overcome the such strong presumption of compliance with Article 6.
Yes, or perhaps more strikingly, if they can't advance the complaint now because they didn't advance it in the originating court, then the task of this court, in a sense, doesn't arise. Those are my sort of framing comments. I apologise, I've taken a bit longer over them, but I hope it's helpful to see the case for case.
The arbitrariness point also is an Article 6 point, right?
Yes.
Yeah. So the first objection to that is the European Court of Human Rights.
Yes. So if I can move on to the legal framework, I had 4 topics that I wanted to address here. The first was, and I'll do it speedily because we touched on this a little in the Brussels appeal, but I did want to return, I had 10 key points in relation to the prism through which you need to view this under Brussels 1. It's all very well to say Strasbourg has looked at cases like Bochen and Anheuser, and this is how it addresses arbitrariness, but of course this court is coming at it through Brussels 1. The second topic was in relation to public policy and the rule is essential in England. The third topic is about what manifestly means, what it relates to. And the third topic is about the test for availing oneself of available legal remedies in the state of origin.
Sorry, you're going to have to go through those again so I understand where you're going.
Yes.
One is the European Court of Human Rights decisions.
No, it's the 34.1. I'm on the legal framework in
Yeah,
Brussels.
34.1.
So it's on 34.1.
Yes, and what you can review.
Yes.
Yeah.
2 is what is public policy and a rule essential in England in particular. And this relates to Article 14.5 in the Customary International. Well, it relates to all of it, but I wanted to go to Kuwait Airways to show the nature of the sorts of obligations.
But what is essential English public policy for the purposes of Article 34.1?
Yes.
Yeah, next.
What does manifestly mean in Article 34.1?
Okay.
And what is the nature of the test identified by Advocate General Spinzar in Diageo and adopted by the court about of needing to avail yourself of available legal remedies in the origin state.
So isn't that a fourth point?
Yes.
What is the
nature of the test for availing yourself of legal remedies in the state of origin?
And that's which paragraph in IGO?
That is the court at 64, adopting Advocate General Spinzar at 63 to 65. So if I can start, I am going to ask if I'm not trying on the patience of the court too much, just to turn up Diageo again, because I just think it is really, you'll have seen the length at which the judge quoted from it in his judgment, and it really is the starting point. It's authorities for. Tab 33. And the judge addresses the case at paragraph 43 of his judgment onwards, and you'll see that it's very much the prism through which he comes at it, and rightly so. The facts of the case Mr. Young addressed you on last week, so I won't take up time with. But if we could just start on page 1189 for me, which is paragraphs 3 to 7 of the court's judgment.
Sorry, I missed the reference.
So it's paragraphs, it's 1189 in high bundle.
Paragraph.
Start at paragraph 3 of the court's judgment. So, I mean, this is just setting out, but it's helpful because it's here, the key parts of the regulation, which is what the court is considering. We note that recital 16 in the preamble refers to mutual trust in the administration of justice in the EU, justifying judgments given in a member state being recognised automatically without the need for any procedure, except in cases of dispute. And then 33.1, paragraph 5, a judgment given in a member state shall be recognised in the other member states without any special procedure being required. Then we have Article 34, judgment shall not be recognised if such a recognition is manifestly contrary to public policy in the member state in which recognition is sought. And then we have Articles 36 and the preclusion of substance review. If we could then pick it up at paragraph 41.
All quoted by the judge.
All quoted by the judge. So, well, 40, it starts with the principle of mutual trust, fundamental importance, area of freedom, security and justice, and the recognition automatically again in the last sentence. And then at 41, in that system, and because of those objectives, the grounds on which the recognition of a judgment may be opposed must be interpreted strictly, in as much as it constitutes an obstacle to the attainment of one of the fundamental objectives of the regulation. So the public policy ground must be interpreted strictly. And then at the bottom, it may be relied on only in exceptional cases, that's Oram and Apostolides, which is the point the judge makes at 43.1 of his judgment. Strictly and only in exceptional circumstances. Then the limits. In accordance with the court's settled case law, states in principle remain free to determine according to their own national conceptions what the requirements of their public policy are. The limits of that concept are a matter of interpretation for that regulation. So that is the EU limits point. My learned friend took you to, I think, the paragraphs of the Advocate General's decision yesterday afternoon, 38 to 39, where he makes the same point. And I understood my learned friend to be citing those paragraphs in support of the proposition that there is an entitlement to review substance. But this is about review of the concept of public policy and where its limits lie. So that's my second point. Thirdly, there is a prohibition on the review of the substance of the judgment. You have that at 43. In that connection, it should be observed that by disallowing any review of a judgment delivered in another member state as to its substance, Article 36 prohibits the court of the state in which recognition is sought from refusing to recognise that judgment solely on the ground that there is a discrepancy between the legal rule applied by the court of the state of origin and that which would have been applied by the court of the state in which recognition is sought had it been seized of the dispute. Similarly, the court...
That's quite a narrow prohibition.
Similarly, the court of the state in which recognition is sought may not review the accuracy of the findings of law or fact made by the court of the state of origin. And that's cited by the judge at 43.3. Fourthly, the clause cannot therefore simply apply on the grounds that a national or EU law rule was misapplied. That's the point, and that's at 49. So over the page. It must next be recalled that the court of the state in which recognition is sought may not, without challenging the aim of the regulation, refuse recognition of a judgment emanating from another member state solely on the ground that it considers that national or EU law was misapplied in that judgment. So it's not okay to simply say there was a rule of Spanish law and you didn't apply it in the way that we say was right. It's not a question of right or wrong. Now, fifthly, the breach must be of a rule regarded as essential in the legal order of the state in which recognition is sought, or of a right recognised as being fundamental within that legal order. That's 44, so back to the facing page. And that's where you have the language. Recourse to the clause may be envisaged only where recognition of the judgment in another member state would be at variance to an unacceptable degree with the legal order of the state in which recognition is sought, inasmuch as it would infringe a fundamental principle. In order for the prohibition on any review of the substance of another member state to be observed, the infringement would have to constitute a manifest breach of a rule regarded as essential in the legal order of the state in which recognition is sought, or of a right recognised as being fundamental within that legal order. So the word manifest is doing the task of protecting against the preclusion, the review of the substance. And that paragraph is cited at judgment 43.4. And if we could just turn back, there's one part, we know from the Advocate General's opinion at paragraph 42 that the word manifest was deliberately added to give expression to the expectation of a manifest conflict. So that's 42, page 1179 in the Advocate General's opinion. Bottom of the page, indeed, the adverb manifestly, added in the course of transformation of the convention into the regulation, gives concrete expression in the regulation to the expectation of a manifest conflict between the recognition of judgments and public policy.
So which paragraph of the EJEC?
Sorry, it was paragraph 42 of the Advocate General's opinion. At the bottom of page 11, the sentence that begins at the bottom of page 1179. And you'll see from our skeleton that the English courts have interpreted that word manifest to mean plainly or obviously contrary to public policy, that's laser point, which I'll come to, or obvious that public policy dictates refusal of enforcement, or flagrant breach, which is Smith and Huertas. We say that those are entirely apt interpretations of what what manifest requires. Seventhly, in addition to being a breach of a rule regarded as essential in the enforcing state, it must be a breach of an essential rule of the EU legal order, and that is Diageo at 50. That's page 1196.
Where are all these points set out, these 7 points?
They are in part set out in the judgment. I don't believe they are set out in this detail in our skeleton given the page limit, but I can provide them if it would be of assistance.
Okay, yeah, okay, well they're mostly in the judgment, but I'm just struggling to see them all as separate points, that's all.
I've lost some of your numbering, I don't think you...
So firstly, public policy ground must be interpreted strictly, only in exceptional cases. Secondly, the limits of the concept are a matter for the regulation. Thirdly, there's a prohibition on review of substance. Fourthly, clause can't apply simply on the grounds that national or EU law was misapplied. Fifthly, the breach must be of a rule regarded as essential in the legal order of the state in which recognition is sought. Sixthly, the breach must be manifest. Seventh, in addition to being a breach of a rule regarded as essential in the enforcing state, it must be a breach of an essential rule in the EU legal order.
Thank you.
These apply equally, of course, to the earlier questions we have to determine on issue estoppel and so on.
Which is why I thought it might be helpful to go back to Diageo, because it is about Article 34.1 generally, and how it's to be applied.
Yeah.
Eighthly, this is the exhaustion of remedies point. Individuals concerned must avail themselves of all the legal remedies available in the member state of origin. This is Diageo 64, page 1198. Save where the circumstances make it too difficult or impossible, with a view to preventing a breach of public policy before it occurs. This rule is all the more justified where the alleged breach of public policy stems, as in the main proceedings, from an alleged infringement of EU law, but it doesn't only apply there. Of course, the complaints that the club has made are made on the footing that they're breaches of both the European Convention on Human Rights and the EU Charter.
I mean, Sir Peter Gross apparently decided that they didn't have to do all that. Is that right? He decided that it was too difficult and
Forgive me, my lord. I'm not instructed in all three appeals, so there may be areas where I won't be the best place to assist the court.
Can I see if I can assist the court? As I understand the position, that my lord, Master of the Rolls' question was directed towards a part of Sir Peter Gross's award, in which he concluded that it was too difficult for the club to take a particular step.
Yeah.
That was actually the step of entering an appearance in the Spanish proceedings.
yes,
That
is the precursor to taking any of these points in relation to the...
That's right. That comes in, as I hope I made clear, at a later stage of the analysis, where actually we're talking about exhaustion of legal remedies. But in relation to the points that Ms. Patel is dealing with now, then, as as I understand it, there's actually very little between the parties as to the relevant position as a matter of EU law. The question really that lies between the parties is whether the judge, in the context of considering Article 36 of the regulation, considered the correct test under EU law. And that's what I was talking about all of yesterday.
Yes.
About if you like, the question of how fundamental the error has to be in order to enable the receiving court to review that error. I hope that's helpful, my lord.
Yes.
Yeah. Yes. Obviously, Mr. Thompson would stand thinking I haven't made my position sufficiently clear. Sir Peter Gross did not have to consider these sorts of human rights.
No, I understand he didn't.
What
He did have to consider whether you ought to have submitted to the jurisdiction.
Absolutely. He had to consider whether we should have applied for a stay on the grounds of the arbitration clause and whether we should actually have applied to, if you like, enforce the pay to be paid determination.
I understand, but what we can't do is decide these questions in one way in one part of the case and another way in the other part.
I understand that, my lord.
It may not be Miss Patel's pigeon to argue it in the other part of the case,
I appreciate
but it's
that.
our pigeon to decide the case consistently and on a legally sustainable basis.
And that's why I rose in the hope that I could be of assistance, because I'm dealing with a number of the pigeon holes, even if not all of them.
Okay. Anyway, you rely on paragraph 64 of Diageo as showing that they must avail themselves of all legal remedies available in the member state with a view to preventing breaches of public policy, and all the more so where it's an alleged infringement of the law.
And there's been some debate in the skeletons about the nature of that test, as well as whether what has happened on the facts of these human rights complaints.
Okay.
And then that is Diageo. Those were the 8 points from Diageo. Then I had 1 point from Cromback, which I don't think we've turned up yet, and 1 point from Moronier, and those will be my points under this head. So if we could just go to Cromback, which is the same bundle, tab 31.
Is this in the judge's judgment?
It is, yes, at 45. So this is the case about the doctor who injects the 14-year-old girl who dies, criminal proceedings, and it's paragraph 25. Well, start at paragraph 23 is where the concept of public policy, the discussion begins. Question turns on the interpretation of public policy in the state in which recognition is sought. Paragraph 24, national public policy, but question about how far the community judicature can interpret the concept. And then over the page, at paragraph 25, sorry, I'm in the advocate. I'm so sorry. I'm in the Advocate General's opinion rather than the court. So, can I ask you to, in fact, turn to page 1143, which is the court's judgment on the second question. Which is whether the court, the state in which enforcement is sought, can, with respect to a defendant domiciled in its territory, charged with an intentional offence, take into account the fact that the court of the state of origin refused to allow that defendant to have his defence presented unless he appeared in person. So it's about the right to a fair trial. No, I'm so sorry, it's the wrong page again. Do forgive me, it's paragraph 25 I want. Paragraph 25 on page 1141.
Well, that's cited by the judge.
That's cited by the judge, and there are 4 points to take from it. The first is, the court has consistently held that fundamental rights form an integral part of the general principles, whose observance the court ensures. And you'll remember that Mr de la Mare showed you last week how Article 6.3 of the Treaty of the Union makes provisions of the Convention into general principles of community law. And then the second sentence, for that purpose the court draws inspiration from the constitutional traditions common to the member states and from the guidelines supplied by international treaties for the protection on human rights on which member states have collaborated or for which they are signatories. In that regard, the European Convention for the Protection of Human and Fundamental Rights has particular significance. So it is, in my submission, very much a focus on fundamental rights of significance to community law within the European space, which has significance when you come to look at Article 14.5 and the fact that very prominent member states, France, Germany, Netherlands, so on, have entered reservations to Article 14.5 ICCPR. And then lastly, to turn up Moronio, which is Authorities 3, tab 25. Check that's right, tab 21. No, that's not right. Authorities 2, tab 21. Apologies.
And this is a case different from Moroni, which is the European Court.
It is, yes. Page. It starts at 594. It's paragraph 25 I wanted to go to, which is at 603. So this is another Article 6 case, which the head note explains a case was revived without notice to the defendant. So it's another Article 6 case. And we see at paragraph 24 the reference to that objective of the Convention to facilitate to the greatest possible the free movement of judgments by providing for a simple and rapid enforcement procedure. The objective would be frustrated if courts of enforcing state could be required to carry out a detailed review of whether the procedures that resulted in the judgment have complied with Article 6. Court procedures differ from one state to another, and the courts of this country should apply a strong presumption that the procedures of the signatories of the Human Rights Convention are compliant with Article 6. And we say that that applies also to procedures in the sense of a presumption that courts can be assumed to apply a process of real fact-finding and reasoning, which is rational.
It's a strong presumption, but it's not irrebuttable. That's what the court says.
Yes, exactly, Manny. And the presumption reflects those principles that you saw in Diageo, the objective of free movement of judgments by simple and rapid enforcement. That's Moroni at 25. The principle of mutual trust between member states. Each court should trust all the others to do their job properly, including appropriate protection for human rights, appropriate through the Brussels prison, manifestly. And this must be especially so in Spain's submission, where the human rights violation relates to the application of the state of origin's own domestic law. So these are not pure European Convention on Human Rights points. They are not pure points of did someone have notice of proceedings. They are points which necessarily involve this court adjudicating on findings of Spanish domestic law. And when you look at the cases that my learned friend relies on in his note, Cronbach, Maronier, Laserpoint, these are cases that concerned convictions in absence or lack of knowledge of proceedings which are reactivated, or delay of 26 years in proceedings that an individual was unaware of. Those are the sorts of cases where reliance on the clause has been upheld. There isn't a case that my learned friend has been able to show you, and the court will be aware, because that's why you've identified this as a hard case. There is no case anything like this where the enforcing state has been asked to engage in detailed reviews of substantive findings of fact and application of Spanish law in relation to questions of causation and loss, where an Article 34(1) complaint has been upheld. Still less with a CLC element, where I hope it won't have escaped the court's notice that there were a number of questions from this court yesterday about how the CLC should be interpreted. Those are questions which, had the Spanish court wished to ask them, the club were obviously not there to answer them. So if I could just then move on to my second topic, which is public policy and a rule essential in England. The concept of a rule regarded as essential concept of a rule regarded as essential in the legal order of England is to be understood by reference to English cases, considering the concept of public policy. And in my submission, those cases show that the bar for identifying a rule of English public policy is a very high one. So our skeleton refers to a number of cases: Estate of Falk, Oppenheimer, and Kuwait Airways. I wanted to just turn up Kuwait Airways, if I may, which is Authorities 2, tab 20. This was obviously about Iraq's invasion of Kuwait and seizure. It's page 350, it starts. Seizure of its assets pursuant to a decree which purported to extinguish Kuwait as a separate state. So very extreme facts. If we could turn to the judgment of Lord Nichols, to page 545.
I think if I remember rightly, Lord Justice Brooke's judgment was probably the longest judgment ever given.
You will see, my lord, that I think this has both.
When do we get to the House of Lords?
545. Yeah, I mean the whole law report is a considerable number of pages, as you can see.
I know. I used to carry it around with me. I lived with this case for 10 years. 545.
Page 545, paragraph 16. It's in the context of the consideration of the concept.
552, electronic.
Yeah.
This is the concept of public policy. Lord Nichols cites Mr Justice Scarman in the estate of Falk. Blind adherence to a foreign law can never be required of an English court. Exceptionally and rarely, a provision of foreign law will be disregarded where it would lead to a result wholly alien to the fundamental requirements of justice administered by an English court. A result of this character would not be acceptable to an English court. Now, a state of fault is in the authorities bundle at tab 16. Don't propose that you turn it up, but the language used there at 698 is a law which outrages its sense of decency, the English court's sense of decency. Paragraph 18 in Lord Nicholls' judgment, he says the exception, despite the lack of precision, the exception to the normal rule is well established in English law. Leading example in this country is given, he goes on to describe, by Oppenheimer and Catamol. That's also in your bundle. It's Authorities 1, tab 17. And that was obviously a case which concerned a Nazi law about confiscation of property and deprivation of citizenship on grounds of race. Racial discrimination, we know, is an accepted rule of customary international law. Bottom of that page, when deciding an issue by reference to a foreign law, the courts of this country must have a residual power to be exercised exceptionally and with the greatest circumspection to disregard a provision in a foreign law when to do otherwise would affront basic principles of justice and fairness, which the courts seek to apply in the administration of justice in this country. Gross infringements of human rights are one instance. And then Lord Nicholls goes on to consider the facts of this case. Top of paragraph 20, the seizure and assimilation in this case were flagrant violations of rules of international law of fundamental importance, beyond argument. Paragraph 22, Article 2.4 of the UN Charter provides restraint on use of force. This is also a principle of customary international law binding on states. That is a well-established rule of customary international law. And he cites an ICJ decision in support of that, which is, as you'll have seen from the Law Commission guidelines which were annexed to the Freedom and Justice Party, decisions of the ICJ on rules of CIL are of particular significance. And then at the bottom of 23, decisions of the Security Council taken under these powers are legally binding upon all members of the United Nations. Again, another ICJ decision. So we, in this case, are concerned with a UN treaty obligation and a committee decision, which is not binding. And then 24, breach of international law by a state is not and should not be a ground for refusing to recognise a foreign decree. An English court will not sit in judgment on the sovereign acts of a foreign government or state. It will not adjudicate upon the legality, validity or acceptability of such acts, either under domestic law or under international law. For a court to do so would offend against the principle that the courts will not adjudicate upon the transactions of foreign states. This principle is not discretionary. Then 26, in appropriate circumstances it's legitimate for an English court to have regard to content of international law. And then in this case, 27 is the question. 28, conceptions of public policy should move with the times. Courts of this country should give effect to clearly established rules of international law. 29, I've already said, gross violation of established rules of international law of fundamental importance. Breach of international law of this seriousness, matter of deep concern to the worldwide community of nations. Such a fundamental breach of international law can properly cause the courts of this country to say, like the confiscatory decree of the Nazi government of Germany, a law depriving them of property will not be enforced or recognised in proceedings, manifestly contrary to public policy. And the same analysis is, a similar analysis is provided by Lord Steyn at 113, that's page 567. Talking about whether the recognition of the resolution would be contrary to English public policy. Over the page, talking about justiciability, 114, breach of international law that would be contrary to public policy. The conception of public policy is and should be narrower and more limited in private international law than internal law. And he quotes from Cheshire and North. You have Cheshire and North in the bundle. That's authorities 8. It makes precisely that point. It also uses the language, enforcement should offend some moral, social or economic principle so sacrosanct in English eyes as to require maintenance at all costs and without exception. Both of those are the single page of Cheshire and North which you have in the bundle. Then again, over the page, it talks about Oppenheimer. In my view, the Court of Appeal, this is between E and F, was right to extend the public policy exception beyond human rights violations to flagrant breaches of public international law. It does not follow, however, that every breach of international law will trigger the public policy exception. The present case is, however, a paradigm of the public policy exception. And he goes on, in response to the argument that the obligations are not incorporated, he says the Security Council decisions are binding on all those nations. H. Charter of United Nations has been adhered to by virtually all states. Few remaining members. It is generally accepted that the principles of United Nations...
this is all very interesting, but it's not actually about Article 34, is it?
It's about Article 14.5 and the argument that the judge was wrong to find that Article 14.5 was not part of English public policy. And you have the judge's reasoning on that. You'll see that he cites
I thought the legal point, when you described the legal points to us, I thought you were saying that the public policy and the rule essential in England under Article 34.1 was what we were considering.
Yes.
So this is a different point.
This is the second point. I've got listed down as Ms Patel's second point. What is public policy, specifically in relation to Article 14.5 and Q8 Airways?
Yeah. There we are. Okay, I didn't get that. I got what is public policy, English public policy for Article 34.1. There we are. I missed it.
So I don't think I could, in my allotted time, give you an account of what all English public policy for the purposes of Article 34.1 encompasses.
No, but I mean, this
so
Kuwait case, you know,
yes.
I did live with it for 10
Yes.
years. This Kuwait case is something completely different.
Yeah.
But if it goes to Article 14.5, that's fine.
The simple point that we say arises from all these cases, Kuwait, Oppenheimer, the Falk case, is that where this exception has been upheld in a non-Brussels context, and the courts have found that international law creates is something that resonates in English public policy, they have been looking at essentially peremptory norms. They have either been looking at the Nazi decree, which was a quintessential violation of the right to not to be racially discriminated against, which is a rule of customary international law, or they were looking at the right of states to exist and the non-use of force, the use of force according to the Charter, which is also a rule of customary international law. And we say that the rule in Article 14.5 does not come anywhere near that standard of being a rule of peremptory norm status.
Okay.
Can I take you to one last paragraph, or you could take the note perhaps, which is Lord Hope at 140, where he makes clear that where there is any room for doubt, judicial restraint must be exercised. That's page 576. As I say, the essence of the public policy exception is that it is not so constrained. The golden rule is that care must be taken not to expand its application beyond the true limits of the principle. These limits demand that where there is any room for doubt, judicial restraint must be exercised. And then Lord Scott at 195 uses the language odious and barbarous foreign legislation. So it is, in our submission, a high bar for English public policy. And you then have on top of that the limits of the concept being for the regulation. we've seen, and the fact that it must only apply in exceptional cases. So if I can move on to my third legal topic, what does manifestly mean? The club's argument is that the requirement of manifestness refers only to the quality of the violation, and that the learned judge's approach turned it into a heightened standard of proof that a violation existed. Spain's position is that that's not right, because Article 34.1 contains two separate requirements.
So what's not right?
The judge
turned it into a heightened standard of proof?
Correct. Well,
the judge didn't.
The club is not wrong that manifestness refers only to the quality of the violation. There are two components in Article 34.1.
What are they?
The first is that we saw in Diageo, the requirement that there is a breach of a rule regarded as essential in the legal order of the state in which recognition is sought, the essentiality rule, or of a right recognised as being fundamental within that legal order. So that's the rule in Diageo, which is about the quality of the violation. And then there is a requirement that the breach be manifest. And we say that that is about the clarity or visibility of the violation. And that requirement of manifestness is what is needed to prevent a review of the foreign decision on the substance. So,
what I don't understand is what you say about the judge turning it into a heightened question of standard of proof, which, if I remember rightly, paragraph 84 or something, we can have a look at it. He did say something a bit like that.
Well, I will come to application when I get to that limb of the challenge, if I may, but we say that in the context of, well, he said at 84, it is not a case where, on an examination of the case, it is plain or obvious that there has been a contravention of the master's fair hearing rights. We say that that is correct, that gives expression to the requirement of manifestness. So we say the judge didn't err.
So you effectively could put it as a standard proof. Is it blindingly obvious? Is there no scope for argument? That's how you're putting it.
Yes, it must be manifest. But we say that's correct. We say that's not an error. And that must be how you read manifest, to stop falling into a review of the substance. It's not a question of is every fact and legal conclusion right or wrong. It's a question of standing back. Does it look like there has been a contravention? Is there a reasonable set of reasoning here? But not.
Are you saying that all the textbook writers that were quoted at us are wrong when they say in order to be able to tell in some cases whether there's been procedural unfairness or manifest unfairness, you've got to look at the substance to a degree?
We accept that you have to look at the judgment. I think it was suggested that you don't look at the judgment at all. You do obviously have to look at the judgment, and you can see from the learned judge's judgment that he looked at the Spanish judgment, because there are references to the judgment peppered throughout. But you don't ask yourself, is the conclusion on these points of fact or these points of law right or wrong? You look at, is there a reasonable route through it?
Is it obviously perverse?
Yes. Is there
I
a
think
yes, my lady? Is that, which we would say comes to the same as asking if there is a manifest.
You have to ask yourself whether it is perverse. If it's not obviously perverse but seems to be all right, then you don't interfere with it.
Yes, and to do otherwise would be to give no meaning to the word manifest.
I think the complaint is about our paragraph 49
Of the learner.
of the judge. The complaint of law is about paragraph 49, where he says, I accept the club's argument that the word manifestly cannot rule out a sufficient investigation of the facts to understand the nature of the violation of public policy contended for. But what manifestly does emphasise is that when there has been such an investigation, it must be apparent that the judgment is plainly or obviously contrary to public policy, as said in Laser Point, or must be obvious that public policy dictates refusal of enforcement, as Cook said in Huertas. And then he said, and this is the point that I think Mr. Hancock criticised, if there is room for serious argument as to whether public policy was contravened, either because it was debatable as to what public policy was, or whether it contravened it, then it would be most improbable that the enforcement was manifestly contrary to public policy. In other words, if there was going to be an argument about it, and he said that added up to saying the burden of proof it was really looking at it as you had to say it was so obvious that there could be no argument, and that's wrong.
But we say that's right. We do say that that's
Okay.
right because if
Well, that's
there
fine. That's fine. I understand that point.
And my lord, with A1P1, you have the intrinsic nature of the convention right requires manifestness. You were taken, I think, to Bokken, which talks about a manifest error, striking and palpable on the face of it, an error that no reasonable court could have ever made, grossly arbitrary. That's paragraph 62 of Bokken. And you then also have 34.1 overlaying its requirement of manifestness. So it's particularly acute in the nature of, in relation to the type of complaint that is raised there. Yes, Mr. Young perhaps puts it better than I have so far. Most improbable, serious argument is not the same as impossible on no reasonable view. So we say it is consistent, the learned judge's approach is consistent with Schaff, which refers to it needing to be obvious, and it's consistent with Laser Point, which I think is the language that's picked up in 49, plainly or obviously. And we say that seriously debatable does not meet the threshold.
Yes, and he also said that he misunderstood the Moroni paragraph, which said that the court of a member state in which recognition is sought may not review the accuracy of the findings of law or fact made by the court of the member state of origin, took them out of context in applying them to the question of fact at 124. Why do you say that's wrong? If you remember, he quoted...
Yes, I've just pulled up 124 to remind myself.
Well, you need to start with where he quoted Moroni 118,
yeah.
that whole passage in which that sentence is found at the end of the paragraph.
Yeah.
And then he applied it at 124. And what Mr. Hancock said is that he just took it out of context. That was not the right way of doing it.
Well, we say that it's right that you can't review the accuracy of findings of law or fact in the sense of saying were they right or were they wrong. It's not a question of right or wrong, it's a question of willfulness. So if
But I mean, I suppose your answer is he actually cited the whole of Diageo, almost the whole of the relevant paragraphs of Diageo, so he fully understood the exercise he was undertaking, because it wasn't just citing Moroni. But the criticism, I think, is that when he actually comes to do the exercise, he just talks about Moroni.
Well, we would say that's also not right. When he comes to do the exercise, he doesn't do nothing because he can't review any findings of fact or law. I mean, there are very dense 4 paragraphs, and as I said at the beginning...
So which are the dense ones? The 1, 2, 3, 4, 1, 2, 4...
3 and 4, but actually, you know, they're dealt with in the 2 skeletons. I mean, the club has articulated their case in somewhat more detail in the 18-page note, but the argument that they put in their skeleton is paragraphs 14.5 and 14.6. And our answers are at 33 to 36 of our skeleton. But there is actually a lot in those paragraphs. And those paragraphs, on proper reading, with the benefit of the argument made against us and the argument in response, reveal that he has looked closely at the 2 judgments. Because he could not have said what he says there without doing so. And you'll see he references the Spanish Supreme Court judgment at 1.3, page 140. He references it again at 4. And he references the provincial court judgment in the Lord asked me to look at a moment ago. On page 442, paragraph 85, is peppered with references to the provincial court judgment. So he has looked at the judgment.
Which is what he said he was going to do in 49.
I mean,
First sentence of paragraph 49, he's saying, I don't accept that you can't look at the judgment. You've got to look at the judgment to the extent that it's necessary to find out whether there's a manifest perverse reading or whatever it may well be.
Yes.
He then proceeds to do it, but he does it by reference to a rather truncated approach to Moroni.
It may be that the set of examples he gives at 124, there might be cases, for example, where there is no attempt at legal reasoning or the result is manifestly made to depend on a matter which has nothing to do with a view of the relevant law or facts. And that's not an exclusive list of categories, which might be problematic. And of course, even with the last of those, the result is manifestly made to depend on a matter which has nothing to do with a view of the relevant law or facts. You'd need to look at the judgment in order to be able to come to that conclusion. So he's looked at it, he just hasn't asked, when I look at the judgment, is the reasoning right? He has said, when I look at the judgment, is there reasonable reasoning which supports it? Is there reasoning which supports it, which is not perverse? Which is not, manifestly perverse or manifestly unreasonable. And you can immediately see that answering that question might not require you to decide every point of debate between 2 experts.
No.
I mean, it somewhat beggars belief that after a trial, and you can see how long it lasted from the front page of the judgment. I think I was only there at the beginning and the end. I wasn't there for the evidence, but you know, it's 8 days, of which the last 2 days were submissions, but the remainder was opening and evidence. And it beggars belief that a judge would have simply said, "I'm not going to."
How can you say that? 8 days. We've had 7 days and we've barely scratched the surface. All right, yes. I think we've got those points. I mean, basically your argument, if I can just summarise it to make sure I've understood it, is that none of the criticisms of Mr Justice Butcher's legal approach is in any way justified. He didn't ignore the arguments about whether or not new facts had been taken into account. Indeed, he looked at them to decide correctly whether they were manifestly perverse. As we've seen at paragraph 124 in particular, he was perfectly clear applying the correct test that the judgment was not manifestly contrary to English public policy as being arbitrary or in breach of A1P1, applying the correct test from Diageo and Moroni, and the argument really about Huertas and Moroni is probably a bit of a sideshow, a laser point. And on Article 14.4, it wasn't said it was a rule of customary international law, and that's not actually a point on which they can appeal, having said it wasn't before. And it was certainly not a part of English public policy, and on that he was absolutely right.
That is broadly right. There is a bit more that I need to do.
No, I'm not. I'm not trying to shut you up. I'm trying to see if I'm with you. If I'm with you, in other words, understanding what you're saying,
yes.
Not with you. I'm not with anybody on the substance of any point. I'm not against you.
No. That's right, my lord. Say that I think we wouldn't say Laserpoint and Smith are a sideshow. We say they demonstrate precisely that approach.
They demonstrate the approach. Yes. No, I mean, I was going to say the dispute, alleged discrepancy between Mr. Justice Phillips and Mr. Justice Cook, as they both then were, is not really a discrepancy.
Correct.
But you can deal with that in more detail. If you want to.
I wonder if I could quickly try and deal with my last legal point before 1 o'clock, which is the availing oneself of available legal remedies point. So we looked at paragraph 64 of Diageo, just to remind ourselves of what it said. As a general rule and quite clearly, save where specific circumstances make it too difficult or impossible to make use of the legal remedies in the member state of origin, the individuals concerned must avail themselves of all the legal remedies available in that member state, with a view to preventing a breach of public policy where it occurs. Now, in Spain's submission, the logic of that rule is entirely obvious. My Lord Justice Voss referred yesterday to a degree of discomfort at the task that he was being asked to embark upon. And the purpose of this rule, we say, is to try and avoid that situation. The best placed court to decide on complaints of the kind that the club now advances is the courts of origin. And it is problematic, to say the least, for a party to stay out of proceedings in the local court throughout, including at the international level, where, as I understand it, the issues about submission may be different, and to make no objection to what are, in effect, findings in relation to its own civil liability, which have been the subject of 4 domestic courts' decisions and 2 international courts' decisions. Because the effect, if those complaints are saved up for the enforcing court, is that the enforcing court is put in an invidious position. Now, the club says that the learned judge applied the wrong test. They say that the principle is paragraph 15.1.3 of their skeleton. They say that the test was obviously, the test enunciated by the Advocate General is in fact the Strasbourg test, but it's a different test. It's page 356 of the core bundle. And so the judge erred in law in adopting the view that the club was required to take any and all avenues, even if they had no realistic prospect of success. Because it's the Strasbourg test, and the Strasbourg test is different. I don't propose to spend a lot of time on it, but the language of Article 35 of the European Convention is different. So you have that in the authorities bundle at tab 1 Volume 1, Tab 9. I don't propose to turn it up. It simply requires that all domestic remedies have been exhausted according to the generally recognised rules of international law. And the club says that that means you need to ask whether there was an effective remedy in theory and practice which offered a reasonable prospect of success. That's 15.1.5 of their skeleton. And they take that from the Strasbourg case law. Now Spain says two things, but on this heading I'm just going to address the test. But overall we say two things. We say it's not the Strasbourg test. Advocate General Spinzard didn't refer to the European Convention test or its jurisprudence in Diageo. And if that's what he meant, that's what he would have said. Furthermore, that rule in the European Convention reflects the rule of customary international law that local remedies must be exhausted before international proceedings may be instituted. And you have that in the Interhandel case, which again we don't need to go to, page 27. It's tab 73 of bundle 8, page 2353. And that is logical because an international court is a further remedy against the state. But we say that the function of the Diageo principle is different. The foreign court is not a further remedy against the state of origin in that sense. Indeed, the principle enunciated by the Advocate General in Diageo is intended to help prevent the foreign court sitting in judgment by focusing the correction of errors in the member state of origin. And we say that's why it's actually a more stringent test. So the test that my learned friend Mr Hancock invites you to adopt, we say it's not the Strasbourg test. We say anyway, I said I had 2 points. When I come to the precise complaints, we'll say that anyway, there were clearly avenues available which club could and should have adopted. There are two decisions from Spanish amparo appeals in your bundles, which I think were not referred to in our skeleton. But one of them shows the Spanish Constitutional Court upholding essentially a complaint of arbitrary irrational reasoning. And another shows the Spanish Constitutional Court upholding essentially a new finding of facts argument. So we say it's simply not right to say that there was nothing they could have done. It was all pointless. And the learned judge was right to reject the idea that the remedies available to them were pointless.
I'm going to stop you there, if I may, Ms Patel. We'll resume at 2 o'clock.
Rise in favour.